Welcome to INAN's Advocate. INAN's Advocate is a platform for lawyers having less than 5 years of practice to come here and deliver a lecture on the topic of their choice. Today we have with us Advocate Jagdish Prasad C. Nadiminti. He is the founder of the Chambers of JP, having offices at Kalyan. He is an independent practitioner, successfully appearing before the Honorable Bombay High Court, trial courts, and tribunals in the region of Mumbai and Thane. He has graduated in BTech in Chemical Engineering in the year 2016. He has graduated his law from the KC Law College in the year 2020. He has graduated his Masters in Law from the Mumbai University in the year 2022, wherein he specialized in constitutional and administrative law. He further holds an advanced diploma in alternate dispute resolution from Nalsar, Hyderabad, which he completed in the year 2022. Today, Advocate Jagdish Prasad is going to speak on quashing of criminal cases. So without wasting further time, I would request Advocate Jagdish Prasad to commence with his lecture. Thank you.
Hello everyone. My name is Advocate Jagdish Prasad Nadiminti and my today's topic is quashing of criminal cases. In this topic, I will start with the definition of quashing, then where to apply for quashing, who can apply for quashing, under what grounds the certain authority can grant you the quashing, and under what grounds, if the scenario changes, scenario to scenario wise, I will deal with it. And in the end, before the conclusion, I will give practical tips for drafting and filing of quashing petitions. Okay, to start with, to understand quashing of criminal cases, it is very basic to understand the word quash. Quash means to annul, to invalidate, or to make void. So, the term quashing means to set aside or to annul that thing. So, quashing of criminal cases, as per the judgments of the Supreme Court, means it is the power of the High Court to set aside or annul FIR, criminal complaints, and criminal proceedings with regards to the grounds as specified in law. So, if we understand this definition, my whole topic is covered around this definition itself. So, as I discussed in the introduction, so this definition tells us what quashing is, that is to annul and set aside. So, who has the power to quash? So, as per the definition, the High Court has the power to quash. So, what can it quash? It can quash FIR, it can quash a private complaint, it can quash any criminal proceeding that includes filing of the charge sheet or after the commencement of the trial. So, how does the High Court, or from where does the High Court get the power to quash this? So, there is no explicit power or explicit provision under any code in this country that gives the power to the High Court to quash. But the section 482 of the old criminal code and section 528 of the Bharatiya Nyaya Surakshit Sanhita gives the inherent power to the court. Inherent as in this is not something new that has been provided to the High Court. It is something it actually has from the beginning. So this provision grants a power to the court to interfere into a proceeding or a matter where there is an abuse of process of court or to secure justice, ends of justice. And while making an application or a petition of quashing, you cannot just invoke section 482 of the old code, as right now section 528 of the BNSS, it has to always be clubbed with section 226 or article 226 or article 227 of the Constitution of India. As in the legal language we say, it is always has to be written as section 528 of BNSS read with article 226 of the Constitution of India. So the article 226 gives special powers to the High Court to entertain certain writs. That is the writ of certiorari, quo warranto, prohibition, mandamus, and habeas corpus. And as per those writ, it can pass appropriate orders. So, as I discussed in the definition, the power is given to the High Court. But what can be caused? What can be caused is an FIR. What is an FIR? FIR is a first information report that is given to the police authorities by an informant. In criminal proceedings, we always make a mistake that when a person is giving information to the police officer, we consider them as the original complainant or the complainant. But when a case is initiated as per an FIR, then the complainant, the police authority or the investigation agency, that is the state, becomes the complainant. But the person or the aggrieved person or the victim is the informant. And the second part which can be caused is a private complaint. Private complaint is when any party goes directly to the court to initiate a criminal proceedings against someone. This private party can also be a state authority which under certain codes can directly initiate a private complaint. Then a criminal proceeding can also be caused. So what can be included in a criminal proceeding? It is the charge sheet, that is a case filed after the investigation is done on an FIR. So that can be caused, and when the case is proceeded, that is after the filing of the charge sheet, the court takes cognizance and it has come to the stage of the evidence. At those stages also, that case can be quashed. So now we discussed who can quash, what can be quashed. Now we are coming to the topic of on what grounds can the High Court can quash the proceedings. So for this, as I said, there are no set provision or law regarding quashing. It is the inherent power of the court. So to understand on what grounds the High Court can quash a proceeding, we have to rely on the judgments of Supreme Court and several other High Courts. And for this, I am relying on three landmark judgments. One is State of Haryana versus Bhajanlal. That is a Supreme Court judgment of 1990. Then I am relying on Amit Kapoor versus Ramesh Chandra. It is again a landmark judgment of Supreme Court of the year 2012. Then I am relying on Indian Oil Corporation versus NEPC, another landmark judgment of the Supreme Court of the year 2006. Now, after reading these three judgments and the guidelines given in those judgments, I have jotted down certain guidelines or grounds on which a quashing petition can be approached. So, when any proceeding, the judgment of Bhajanlal clearly states, like as I explained to you, a FIR can be quashed, a private complaint can be quashed, a criminal proceeding can be quashed. This has not come from my definition. This has been expounded in the judgment of Bhajanlal, which clearly starts with where the allegations made in the first information report, complaint or proceedings taken at the face value, that is prima facie, if there are no allegations which constitute an offense, then that has to be quashed. And if again in an FIR or any proceedings, it shows that it is amounting to a non-cognizable offense. Cognizable offense is something where police can directly arrest you or investigate without the permission of the court. And if it is a non-cognizable offense, the police officer or the investigating agency has to take permission from the court before arresting or investigating that offense. So, if any proceeding, FIR, be it a complaint, shows that it is a non-cognizable offense has commissioned and not a cognizable offense, then that proceeding can directly be quashed. And when the allegations or the ingredients of an offense mentioned in any complaint is so absurd that any prudent person cannot come to the conclusion that such an offense was committed and this offense was committed by such person. In such scenarios also, quashing can be done. And during a quashing, these guidelines also tell us that the first guideline itself told us that prima facie it should be looked at. So whenever a court is going into a quashing petition, it has to prima facie see the evidence brought on by the prosecution. Prosecution, that is the state or the investigating agencies. So on the face of it, if there is no offense committed, then it can be quashed. So, but as it is clearly stated prima facie, the high courts cannot go and appreciate the evidence. By appreciating the evidence, I mean it cannot go into the merits of the evidence or into the depth determining whether a reasonable doubt is being created, but only on the face of it they have to look at. And another major ground is whether while adjudicating a quashing petition it comes to the notice, or while adjudicating the FIR also it comes that such an offense has been made by a person because he has a vengeance, a private vengeance, and because of that malicious intent he has started a criminal proceeding against that accused. When this is proved on this ground also, a FIR or a complaint can be quashed. It is not necessary, like I said, the prima facie the offense should be made out, but not necessarily that all the ingredients of the offense should be meted out in the FIR. But if the factual scenario is well written and it can actually tell us that some offense has occurred, in that case the court will not be ready to quash your petition. And one thing that we have to be very careful while understanding these things is, these grounds, that whenever such grounds are being mentioned, it is the duty of the accused to make sure that his petition is in lines with these grounds and not to create a fictional story just to safeguard himself. So as we understood, the judgment of Bhajan Lal told us that a FIR can be quashed, criminal proceedings can be quashed. There is a recent judgment, 2024, it has come in the last month itself, of the Shailesh Bhai Ranchod Bhai Patel and another versus State of Gujarat. This is a judgment of the Supreme Court of 2024, which says that once a charge sheet has been filed, the High Court cannot decline or dismiss a quashing petition stating that a charge sheet has been filed, therefore you have to go to the lower court and apply for discharge. But if there is an abuse of court process or to secure justice, you can still invoke the inherent powers of the High Court and approach them stating that this petition should be quashed. Then again, as I was talking about the malified intention, like if a criminal proceeding has been initiated because of the malified intention of some persons or the victim himself or herself, but as the guidelines told us that we have to only look at the evidence given by the prosecution, that is the state authorities. But how will we show that the malified intention has been there? So in this case, the Supreme Court in the landmark judgment of Mahmood Ali versus State of UP, this is a 2023 recent judgment, the court stated that when there is a ground of there is a malicious intent behind the to keep the accused behind the bars, in this case, the court has not only to look at the evidence brought on by the state agencies, but it has to also look at how the FIR was filed, why the FIR was filed, how the investigation has come to, how the material for investigation was collected, and how that case was formed. So for this scenario, it has to go beyond its regular practice. It has to look beyond the evidence brought on by the prosecution, that is the state. And again, Kerala High Court in a recent judgment of 2024 in the case of Jeeta Sanjay and others state that it is the duty of the court to look into other materials when the allegation of malicious intent or a vengeance to be put upon the accused has been made. In that case, it is primary duty not to just set aside the quashing petition stating that it has not been made out in the evidence brought by the prosecution. Now, the most famous and the most current going on and most easy quashing petitions that there are. And this is more appropriate and most, as I said, famous in the circles of family law and the commercial law. This is consent quashing. So, consent quashing is the ground where an offense has been committed, the informant and the accused have come to a settlement, and on the basis of that settlement, they approach the High Court and they tell the High Court that a settlement has happened and please grant us a please quash the proceedings that has been initiated against us. So there is a landmark judgment of Gyan Singh versus State of Punjab of 2012, and this was again reiterated by the Supreme Court in the another landmark judgment of Narendra Singh versus State of Punjab, which stated that when a settlement has occurred between the parties and a quashing petition is approached, such a quashing is different from compounding of offences under section 320 of the old CRPC. So when there is a non-compoundable offence, then too we can approach the High Court and tell them that the settlement has occurred. But in this case also, the judgment of Gyan Singh directly says that if the offences are of such gravity and such moral turpitude, like the offences of murder, rape, dacoity, etc., which have the effect on the society en large, and when the gravity itself is so much, in such cases the settlement also cannot be entertained. But in the cases of family disputes or commercial transaction which have been given a color of criminal, so in this case the remedy and the difference that has happened is still private in nature. In such cases, a consent quashing can be allowed. But this but is very important. Directly, if there is a private nature offense and you go for quashing, it will not be quashed. The court is going to look at each and every fact of the case, and only in that case it is going to be allowed. Then again, but it is very unjust if for saying that the Gyan Singh is telling us that when a heinous crime has happened, again the heinous crime is as per the FIR and the prosecution evidence that has been brought upon. But what if in such situations, if there is a settlement, can it be solved? Just basis on the gravity of the offense or the letters, the numbers stating that this section is of very grave nature, therefore we cannot quash. Therefore, in the case of Madhya Pradesh versus State of Madhya Pradesh versus Lakshmi Narayan, this is a 2019 Supreme Court judgment in which it clearly states they can directly, you cannot deny it. You have to look at the facts of the case, and if it is that such an offense is not meted out in the evidence but just mentioned in the FIR and the charge sheet, the section has been mentioned, and the prosecution has failed to provide the ingredients in their investigation, then such a settlement should be allowed. And then again, this is a recent 2020 Delhi High Court judgment of Mukhtar Ali and others versus the state of NCT Delhi. In this case, there was an offense of 307 of IPC and Arms Act. In that case, the court looked into the charge sheet and found out the ingredients are not meted out. But there has been a settlement. So because of that, we cannot let the accused run in the criminal justice system for years until he can be acquitted. But as I said, again going back to Gyan Singh and Narendra Singh, which they say heinous crime cannot be absolved because it has an impact on the society, as in very instances we have heard in news where the rape victims are made forcibly married to the accused or made to tie rakhi with the accused, and on those grounds certain high courts have granted them quashing, which has been overturned by the Supreme Court again. So this was in a very recent judgment of the Meghalaya High Court of 2024. This is a Senzin Sefel and another versus State of Meghalaya. This was an offense of rape in which the settlement had occurred with the victim. So in that case, the court held that even if it is assumed at this juncture that the survivor has forgiven the petitioners, there is nothing in law which can result in quashing of the proceeding on the basis of such forgiveness. The court, relying on Gyan Singh, said that the Supreme Court has laid down the serious offense such as rape cannot be settled or withdrawn based on forgiveness from survivor or any agreement between the parties. So these were the general grounds. Now I have few more grounds on the basis of which we can approach the High Court for caution. So if imagine there is a procedural irregularity. So what do you mean by procedural irregularity? So I give you an example. If the arrest and the investigation have not been done in a proper manner and this is affecting the accused in a very, very bad manner. So in that case, the example of state of Uttar Pradesh versus Ram Swaroop, this is a landmark judgment of Supreme Court of 1980. The Supreme Court caused the proceedings due to the irregularities in arrest and investigation. Then if we go ahead, if there is a delay in FIR, this trend delay in FIR means that when the incidents, that the crime or the offense which has occurred on a certain date and there has been a considerable delay in informing this to the police or bringing it to the notice of the court. So on the basis of this delay itself, a FIR can be caused. And this trend is generally observed in sexual offenses or offenses which are of commercial nature, of fraud, forgery, like white collar crimes. So there is a recent judgment of the Gujarat High Court. This is Apurva Oza versus State of Gujarat of 2023 judgment, in which the accused was alleged with the offenses of molestation. 354 was invoked against him, and there was a delay in the FIR which was not explained in the FIR. And as this was done with a vengeance against the accused, and even the FIR did not meet the conditions of the 354. So on these three grounds, the FIR was quashed. So now I would like to tell you why I have taken this topic. And the reason for telling this now is because it is very important to know the grounds before understanding why quashing as a remedy is very important. Because generally, a recent case in Bihar in April 2022, a man was acquitted after spending 28 years in jail. This is a gross abuse of process of court. And for securing justice, you have to invoke a quashing petition. In my very short span as a lawyer and even as an intern, I have seen a lot of cases where advocates are not looking at the ingredients of the files which they have, or the courts are also not going into the charges that are brought in front of them, and mechanically the charges are framed, mechanically the lawyers are allowing that charges to be framed, and the case goes on for years and years. And because of that, the accused has to face the depravity of that judicial system. And once a case is registered against you, you cannot apply for a white collar job. In every background check, that offense or that the registration of that case will always be shown, and because of which you cannot enjoy your life. Therefore, it is a very important remedy. Not in all cases it will be effective for you, but if you meet the grounds as I stated above, it would be a good efficacious remedy for you. Now coming back to the topic. As I said in the beginning, you have to invoke the inherent powers under section 482 of the old code or section 528 of the new code, read with article 226 of Constitution of India. But if any time you have to invoke the writ jurisdiction of the court, you have to satisfy to the court that you have exhausted all other alternate remedies, or why you have directly come to the High Court without exhausting those remedies. So similarly, like as I explained how charges are mechanically framed, when a charge sheet is filed, you have the remedy of applying for the discharge. If that discharge is denied to you, you can, in revision, you can go to the revision court and you can file a revision against that discharge order. And once that is denied, you can go to the High Court. But if this process is abuse of process of court or is not securing justice, you have to satisfy to the court how these things are fitting for your case. And only then your petition is going to be entertained. And as per the appellate rules or as per the new action plan, if your accused is a senior citizen, then you can directly move to the High Court. Senior citizen, that is above the age of 60, he or she, then you can directly approach to the High Court and inform to the High Court that my client is old and he's a senior citizen. In that case, I may be given a leave of not entertaining the alternate remedy and directly coming to this court. So, in the case of Dharimal Tobacco Products and others versus State of Maharashtra, this is a case of Supreme Court of year 2009. In a similar manner, the court held that even if the person has the remedy of revision, he can still invoke 482 and come to the High Court. Now, as these were the grounds of how we can approach a quashing petition, now using these grounds, I will try to guide you regarding practical tips for drafting and filing of a petition. So now coming back to the definition of quashing of criminal cases, this is the inherent powers of the High Court to null or invalidate FIR, complaint or any criminal proceedings which are validated as per the legal grounds. The ground have just been explained. So where can you file a quashing petition? You have to file it in the appropriate High Court. So against what can you file it? So first you have to determine whether you are going for a quashing of the FIR or whether you are going for the quashing of a private complaint or you are going for the quashing of a criminal proceeding. Criminal proceeding can differ if it is just at the stage of charge sheet, after the framing of charges, or the evidence have started. So you have to mention this in your petition at what stage or against what you are using the quashing. Then you have to correctly write the sections. After 1st July of 2024, you have to invoke the inherent powers under section 528 of BNSS, read with, this is very important, read with article 226 of the Constitution of India. Recently a friend of mine applied for quashing, but he forgot to write or mention the article 226 of the Constitution and his petition was lying for objection for weeks. And next point is you have to add the necessary parties. Necessary party means as the accused is the person who is going to approach the court, he is the petitioner. So in the respondent side, you have to check at what stage your case is. If it is just at the FIR or the investigation stage, then you make the investigation agency as the party through the public prosecutor. And you have to make the informant also a party. Because a quashing petition cannot be entertained without giving sufficient opportunity to the informant. Because a victim or an informant is directly affected by the result of the criminal proceedings. So this was held in the case of Satyapal versus State of Uttar Pradesh. This is a case of Allahabad High Court, which stated that informant is considered a necessary party in proceedings seeking to quash an FIR and should be given an opportunity to be heard before a final order is passed. And the landmark judgment of Jagjit Singh, which says the victim has the right at every stage of the criminal proceeding, and that is thus not limited to the criminal trial. This includes your revision, appeal, and any proceedings leading up to High Court and Supreme Court. So, coming to the drafting part, we discussed the court. This will come in your cost title. Then, which sections and article you are invoking, that has been mentioned. The necessary parties, and what are you looking to quash. Then after that, you have to write down all the necessary facts of the case. Then arrange them in a sequential, that is in a date manner. Then you have to add the grounds that is applicable to your case. You have to rely on the relevant citations, find from them which grounds are matching to your case. If it is a case of malified intention, then go and find evidences which will support your case on that ground. If you do, only then you can request the court to look beyond the evidences filed by the state. And you have to specify your prayers. As I said, you are clubbing it with writ. So if whether which writ you are invoking, it is a certiorari, prohibition, quo warranto in the cases if a court which does not have the jurisdiction has taken the jurisdiction, if the right investigation officer is not been appointed, and if you're trying to prohibit them from continuing this, then in that case you have to use certiorari or prohibition. And when it comes to consent quashing, so when it comes to consent quashing, always make it a point with consent quashing petitions, you have to mention in your petition that the victim or the informant has given their consent to you with free will to quash these proceedings. If there are certain consent terms or an agreement that has occurred between you, both parties, please mention in your petition, and again attach an affidavit of consent of the victim. And always make sure whenever you're appearing before the court that the victim is always present in the court. If the victim is not present in the court, your consent quashing is not going to be entertained. But there is one small problem that happens. In cases of family disputes, after various cases, criminal, civil, has been filed between husband and wife, they finally reach a settlement. The wife agrees that she will give the consent for quashing, but she does not appear for the quashing proceedings. And because of that, the accused, that is the husband of the family, are stuck and they cannot move ahead. As I said, court is not going to grant you quashing if the victim is not present in front of the court. So a effective remedy for this is, if you have any cases going on in the lower court and the settlement has occurred between the parties, apply for mediation in front of the court. And when the mediation is approached, try to enter into a settlement agreement or a consent terms. I would prefer a settlement agreement as per the Mediation Act. And in that mediation, get it, as both the parties are going to sign that agreement, get it ratified by the mediator. It is going to be a presiding judge. And if this scenario is happening pre-litigation, that is before filing of litigation cases, already a settlement has happened between the parties, go to the nearest district legal services authority office and apply for mediation. And in that mediation proceedings, enter into a settlement agreement, get it ratified by the mediator. Why I am emphasizing on this is because when that settlement agreement is ratified by the mediator, it is equivalent to an arbitral award, and that arbitral award is equivalent to a decree of the civil court. So when you're going for quashing and the victim is not coming in front of you, you can show this settlement agreement, and on the basis of that settlement agreement, because it holds the power of a decree of a court, so on basis of that you will get the quashing. And in any case, even if the victim shows up, I say take due care and sign these agreements. And this is not my word. Please read the new Mediation Act of 2023, which explicitly talks about this. Then again, while we were on the subject of prayers, if you are required, if this is not a consent quashing, this is a normal quashing proceedings, if there is an interim needed, so interim as in you, while the quashing petition is being dealt with, if you need a stay on the lower court proceedings, on the stay on the investigation, or stay on your arrest, in that scenario, it is very advisable to specifically write the interim prayer and press for it. And always check the assignment of the bench in which High Court you are applying. And once that has been checked, always try to go through the previous orders of those court. If it is very beneficial in a case, because certain judges have a style or they rely on certain judgments. If you use that language or rely on that judgments, it would be very beneficial for your parties. And in certain cases, like there is a trend in the Bombay High Court sometimes in some benches that a cost is imposed when there is a commercial nature has been, a commercial transaction has been converted into a crime. So in that quashing, generally cost has been imposed. So you have to look how much cost is being imposed and how much it can be brought down. So on these grounds, I have explained to you how the drafting can be done. To conclude again, I will come back to the definition of the quashing of criminal cases, that is the power of the High Court to null, set aside, or invalidate a FIR, complaint, or criminal proceedings which is under the legalized grounds. So it is very clear who can file. It can be filed by an accused of a crime. Where it can be filed in the High Court. What grants the power to the High Court? It is the inherent powers, that is section 482 of the old code and section 528 of the BNSS, read with article 226 and 227 of the Constitution of India. And the major grounds have been discussed above. And even if there is an alternate remedy, if you can show to the court that there is severe injustice happening against you, you can directly approach for caution. Thank you very much. I conclude my presentation. I thank the team of Hammurabi a lot for giving me this opportunity. Thank you.
So Jagdish, thank you very much, because this was a very topic which apparently may look very small, but the manner and the method in which you have done the research, you have been quoting the very recent judgments of 2024. So that goes to show that how in depth you have studied this topic. And I think because of your this particular lecture, lot of people will have clearance as to what is quashing, kaise janega, what should be the prayers. So thank you very much for this. A small
you, sir.
token from us to you.
Thank you very much, sir.